I want you to meet Dorothy. Dorothy is 71 years old. She lives alone in the same house she and her husband bought 34 years ago. 3 years ago, she lost her husband after 42 years of marriage. Her nearest neighbor is a quarter-mile down the road. For over 2 decades, Dorothy has kept a legally registered firearm in her home, not because she is afraid, because she is prepared, because she is a responsible, independent woman who decided long ago that her safety was her own responsibility. Last year, her state passed a sweeping new set of gun-carrying restrictions. New permit requirements, new training mandates, new fees, new renewal timelines. When her daughter called, worried, she said, "Mom, I think you have to give up the gun. The new laws are clear. You need to requalify, get a new permit, take a course." Dorothy almost believed her. But here is what Dorothy's daughter did not know, what her local police department never told her, what the news channels covering the new law never once mentioned. Dorothy was legally exempt. Every single one of those new requirements, the requalification, the new permit, the mandatory training, the extra fees, none of them applied to her, not because of some shady loophole, not because of a technicality, because of specific, clearly written legal protections designed for senior gun owners exactly like Dorothy. Protections that most seniors in this country have never been told about. Think about that for a moment. How many responsible senior gun owners are sitting at home right now, watching the news, listening to worried family members, and believing they have lost rights they still legally possess? How many are quietly preparing to surrender firearms, cancel permits, or give up carrying altogether simply because nobody gave them the complete picture? The answer is staggering, and it is happening right now in communities across this country, one confused senior at a time. This is not always malicious. Sometimes the people giving wrong information genuinely believe what they are saying. A well-meaning daughter, a neighbor who heard something at the coffee shop, a clerk at the permitting office who misread the statute, a news anchor who reported what changed but never once mentioned who was exempt. None of them are necessarily lying. But belief is not law. And in the dangerous gap between what you are told and what the law actually says, good people surrender firearms they had every right to keep. Think about who is most likely to voluntarily surrender a legally owned firearm because of a misunderstanding. It is not the 30-year-old with a lawyer on speed dial. It is not the busy 45-year-old who will research statutes online for 3 hours. It is the 70-year-old who trusts the evening news. It is the retired veteran who follows the law without question because that is who he has always been. It is the grandmother who would rather give up her firearm than risk doing something wrong, even when doing nothing wrong is exactly what the law requires. That trust is being exploited through silence. Every time a new law passes, the coverage follows the same script. Here's what changed. Here's what everyone must do now. What that coverage almost never includes is this. Here is who is specifically exempted, and seniors are being hit hardest by that information gap. Senior gun owners have real, powerful protections in both federal law and in many state statutes. Age-based exemptions, grandfather clauses, disability accommodations under federal law, home storage rights that stand completely separate from carry rights, financial hardship waivers, and clear protocols for when someone in authority gives you incorrect information. Today, we are going to walk through 6 of those protections in plain language. If you are a senior who legally owns a firearm, or if you have a parent, grandparent, aunt, uncle, or neighbor who does and is worried about new laws, this is for you. Share it right now before you do anything else, because the person who needs this information most is probably not the one searching for it. Protection number 1, age-based exemptions and new permit laws. Many states that have introduced new carrying permit requirements have built explicit exemptions directly into the law for gun owners above a certain age, typically 65 or older, who have held a valid permit for a continuous number of years. In these states, qualifying seniors are not required to requalify, retest, or pay new fees simply because the law changed. This is not a rumor. It is written into the statutes. Why does this exemption exist? When legislatures pass new gun laws that add burdens on existing permit holders, courts examine whether those requirements create what is called an undue burden, especially on seniors. Mandatory physical and cognitive testing can unfairly impact older Americans with normal age-related limitations that have nothing to do with safe or responsible firearm ownership. Several states addressed this directly by writing age-based carve-outs into the new laws before they ever took effect. But here is the critical point. Do not assume your state has this exemption. You must verify it. Go to your state's official Attorney General website or the state legislature's official statutory code online. Search for your carry permit statute and look for language referencing exemptions for permit holders over 65, waivers of requalification for seniors, or grandfathered status for long-term holders. If you are not comfortable navigating that yourself, contact a gun rights attorney in your state, not the police department, not a gun store clerk, an attorney, because the stakes are too high for guesswork. This single protection has already saved thousands of seniors from unnecessary retesting and fees. Most of them still do not know it exists. Protection number 2, disability accommodations for seniors with physical limitations. Most people never connect firearm regulations with disability protections, but they should, because federal disability law applies in every single state, and it prohibits discrimination against individuals with disabilities in government programs and services. Think about the reality many seniors face: arthritis, mobility challenges, hearing loss, vision impairments, chronic pain conditions, balance issues, medical limitations that come naturally and honestly with age. None of those conditions automatically make someone irresponsible. None of them automatically eliminate constitutional rights. That is precisely why accommodation protections exist. Many new state gun training mandates are run or approved by government agencies. If you or a senior you love has a mobility limitation, hearing impairment, vision issue, or any other qualifying condition that makes standard training difficult or unsafe, you may be legally entitled to reasonable accommodations. This could mean an adapted training format, a written assessment instead of a range qualification, a home-based evaluation, or other adjustments depending on the situation. The key word is request, because accommodations do not happen automatically. You must request them properly, usually in writing, with supporting documentation from your physician. The accommodation process is not a way to avoid responsibility. It is a legal mechanism designed to ensure that legitimate physical limitations do not become an unconstitutional barrier to exercising a constitutional right. Do not surrender your firearm. Do not skip required steps without guidance. Talk to a gun rights attorney, gather your medical documentation, and submit a formal accommodation request before you assume there is no path forward. Most seniors never make that request. They assume the requirement is absolute, that there is no alternative, that they have reached the end of the road. Assumptions are dangerous when rights are involved. Protection number 3, the power of grandfather clauses, and the one mistake that destroys them. You have probably heard the word grandfathered before, but most people do not fully understand how powerful it can be for senior gun owners, or exactly where it stops protecting you. When a new gun-carrying law passes, many states include what lawyers call a grandfather clause. This clause protects people who were already in compliance with the old law. For seniors who have held valid permits for years or even decades, this protection can be a lifesaver. Here's a real-world example. A state passes a new law requiring all carry permit holders to complete a brand new 12-hour training course and requalify at the range before their next renewal. But the grandfather clause in that same law says that anyone who has held a continuous valid permit for 10 years or more is exempt from the new training requirement. They only need to complete basic renewal paperwork. Dorothy, who has held her permit for 22 years, falls squarely under that protection. She does not owe the state a single extra training hour or range visit. This is not luck. This is deliberate legal design. Legislatures know that suddenly forcing long-time law-abiding seniors through entirely new hoops could be both unfair and potentially unconstitutional. But here is exactly where so many seniors go catastrophically wrong with grandfather clauses, and this one mistake causes more unnecessary firearm surrenders than almost anything else. A grandfather clause protects what you already had. It does not automatically protect you if you let things lapse. If Dorothy allows her permit to expire, even for 30 or 60 days, she could lose her grandfathered status entirely and suddenly face the full new requirements when she tries to renew. The protection depends on continuity. That is why the single most important immediate action any senior gun owner can take right now is this: do not let your permit expire. Even if you are confused about the new law, even if you are not sure what is required, even if you are questioning whether you still want to carry, keep that permit active while you figure everything out. Renew first, understand later. Because once the permit lapses, you may lose the very shield that was protecting you from the new rules, and getting it back can be far more difficult and expensive than simply maintaining it. Protection number 4. Home storage rights are completely separate from carry rights. When seniors hear about new carrying laws, new permit requirements, and new restrictions on where a firearm can be taken, many immediately arrive at the same conclusion: I guess I have to give up my gun. That conclusion is completely and absolutely wrong. Your constitutional right to keep a firearm in your home for self-defense is separate from your right to carry that firearm in public. The U.S. Supreme Court made this crystal clear in District of Columbia versus Heller. The right to keep a firearm in your home is a fundamental right that does not depend on any permit, any training certificate, or any public carry law. New carrying restrictions affect your ability to take the firearm outside your home. They do not require you to surrender a firearm that stays legally stored inside your house. Dorothy does not carry a gun to the grocery store or the doctor's office. She keeps her firearm secured in her nightstand because she lives alone on a rural road, and she wants to be able to protect herself if someone breaks into her home in the middle of the night. No new carrying law touches that fundamental right, none. This distinction is vital. If you or a senior you love owns a firearm purely for home protection and has no interest in public carry, most of these new state carrying laws are largely irrelevant to your situation. You need to be aware of them, but you do not need to surrender your home protection firearm because of them. Your home is still your castle. Know the difference between carry rights and keep rights. They are not the same legal question, and confusing the two is one of the most common and costly mistakes senior gun owners make. Protection number 5. Financial hardship waivers for permit fees. New permit requirements almost always come with new costs. Application fees, training course fees, range qualification fees, renewal fees, fingerprinting fees. For many seniors living on fixed incomes, Social Security, pensions, limited savings, these added expenses create a serious and real barrier. What most seniors do not know is that many states have built financial hardship waiver provisions directly into their permit systems. These waivers allow qualified applicants to have fees reduced or eliminated entirely if they can demonstrate financial hardship. This is not charity. It is not a favor. It is a legal mechanism designed to prevent money from becoming an unconstitutional barrier to exercising a constitutional right. Courts have repeatedly recognized that if a right can only be exercised by those who can afford the fee itself raises serious constitutional problems. Here is how to access this protection. When you apply or renew your permit, specifically ask the permitting authority whether a financial hardship waiver is available. Request the process and required documentation in writing. Then gather your proof. Recent tax returns, a Social Security award letter, or bank statements, and submit the waiver request formally alongside your application. If your state does not have a clear waiver process and the fees feel prohibitive, that is the moment to speak with a gun rights attorney. There is established case law supporting the argument that excessively high permit fees can violate the Second Amendment as applied to low-income individuals. That argument has succeeded in court before. Your constitutional rights do not disappear when you retire. Do not let fees stand between you and your legal protections. Protection number 6. Your protocol when someone in authority gets it wrong. This final protection may be the most practical one in this entire video. All the legal rights in the world mean nothing if you do not know how to respond when someone in a position of authority tells you something that is simply incorrect. An officer at a traffic stop tells a senior her permit is no longer valid under the new law. A clerk at the permitting office insists a grandfathered senior must now requalify. A well-meaning family member is convinced the new rules mean the gun has to go immediately. None of these people are necessarily lying. Some genuinely believe what they are saying, but belief is not law. And in the gap between what you are told and what the law actually says, good people surrender firearms they had every right to keep. Here is your clear step-by-step protocol. Step 1. Do not surrender your firearm on the spot, not to a police officer, not based on a phone call from a government office, not because a family member is worried. Your firearm is legally owned property, and voluntarily surrendering it is a decision that can be very difficult to undo. Step 2. Write down everything immediately. Who told you what? When did they say it? What specific law or requirement did they cite? The more detailed your notes, the more valuable they become to an attorney. Step 3, contact a gun rights attorney before you do anything else. Today, not tomorrow. In most states, even if there is a legitimate issue with your permit, you have appeal processes, waiver options, or correction pathways available, but those processes have deadlines. An experienced attorney can navigate them quickly. Step 4, reach out to your state's Attorney General office or a reputable gun rights organization. Many provide free or low-cost guidance for exactly these situations. You do not have to figure this out alone. You have worked too hard for too many years to let incorrect information take your rights away. Let me bring all 6 protections together so you can see the complete picture. First, many states explicitly exempt seniors over a certain age who have held permits for years from new requalification and training requirements. Verify whether your state is one of them. Second, federal disability law requires reasonable accommodations for seniors with documented physical limitations and government-mandated training programs, but you must request them properly with documentation. Third, continuous long-term permit holders are often protected from new rules under grandfather clauses, but only if you keep your permit active and never allow it to lapse. Fourth, your constitutional right to keep a firearm in your home for self-defense stands completely separate from any public carry law. New carrying restrictions do not require you to surrender your home protection firearm. Fifth, many states allow seniors on fixed incomes to have permit fees reduced or waived entirely. Ask for the process in writing and submit proper documentation. And sixth, when told something that sounds wrong, stay calm, document everything, do not surrender your firearm, and consult a gun rights attorney immediately. Dorothy kept her gun, not because someone bent the rules for her, not because she received any special treatment. She kept it because she discovered what her actual rights were. They were clear, they were established in law, and they protected her from requirements that simply did not apply to her. She is a responsible, independent woman who made a decision decades ago about her own safety. And thanks to these protections, she continues to live that way, with peace of mind, with dignity, and on her own terms. If you are a senior gun owner right now, or if you have a parent, grandparent, aunt, uncle, or neighbor who legally owns a firearm and may be worried about new laws, do two things immediately. First, share this video right now. Do not wait. Do not finish watching and think you will get to it later. The person who needs this information most is probably not actively searching for it. They are trusting the news, trusting a family member, or sitting alone feeling pressured to give up something they have every right to keep. Your share could literally protect their rights today. Second, subscribe and turn on notifications so you never miss an update. This exists to cut through the noise and deliver the complete legal picture to the people who need it most, seniors who value their independence and their constitutional rights. You are not alone in this. There are millions of responsible senior gun owners across America who have earned the right to protect themselves and their homes. The law recognizes that. Now you know it too. Knowledge is your strongest defense. Preparation is your responsibility, and your rights are worth protecting. What if an officer shows up at your door one day and tells you that you are required to surrender your firearm for inspection or registration under a new law? What exact words should you say? What are your rights in that specific moment? Those situations are happening more frequently across the country, and most seniors are completely unprepared when they occur. In the next video, we break down exactly what to do when that happens, the specific language that protects you, the mistakes that hurt you, and how to handle those encounters without giving up a single right. I will see you there. Stay safe, stay informed, and keep your guns, because the law is on your side.